We've gone a few lessons without looking at electronic crime law, so let's look at several others that are on the books and apply to some of the activities that we may see in the course of investigating activities in the company. We've already looked at the CFAA, the Computer Fraud and Abuse Act. We've looked at the Digital Millennium Copyright Act, and we looked at the Espionage Act. What I'd like to do in this unit is look at the Electronic Communications Privacy Act, the Pen Trap Statute, Foreign Intelligence Surveillance Act, and the U.S. Patriot Act. Electronic Communications Privacy Act was enacted in 1986, and it extends government restrictions on wiretaps from telephone calls to transmissions of electronic data. So we're looking at files and emails that are in a transient state. It also allows an ISP to look through all stored email and files under carefully established scenarios. It prevents those ISPs from revealing information in the files without the proper warrants and administrative subpoenas. So the investigators often need to obtain the destination, origin, or even contents of certain communications. And normally this information is considered private. So you can imagine if there are activities taking place with your employees, such as downloading child pornography, law enforcement would be interested not only in that individual who's conducting that activity, but also where that activity may have originated and where there may be other people who are collecting or distributing that particular type of data. The ECPA was designed to prevent misuse of computer information and protect all forms of electronic communications. It prevents unlawful access and unlawful interception of electronic communications. To intercept electronic communications, law enforcement officers must follow very specific procedures and obtain a court order that meets very rigid requirements. But it's more flexible in accessing stored electronic communications than what we've had in the past. They can use administrative subpoenas authorized by a federal or state statute and court orders or subpoenas that are issued by the court. Distinction needs to be made between stored and intercepted communications, as intercepting communications is potentially a greater invasion of privacy. So stored communications are like your email that's in your email box. If I intercept your email on the way to your email box, then I'm intercepting a communication, and it's sort of like an electronic wiretap. But there are different rules that apply to communications that are on the wire. But stored communications are covered by the ECPA. So there's always a question of the expectation of privacy that people have with respect to their activities on a computer. Or even in this case, the video rental places and books loaned from a library. You're expecting that if you rent a video, that nobody is going to examine what your rental history is. And if there are books loaned from a library, nobody's going to examine what your books are that are loaned from the library. Now, if you happen to do a search on Google, all bets are off. Limitations do arise to that expectation, however. If a computer user had no reasonable expectation of privacy, a warrant is not required. So this would be the case if a company issues an employee company computer. Because once I issue you a company computer and I have made it a policy that you should expect no expectation of privacy, then that lays out a different legal scenario than if you're using your own computer and I had no policy in place. In the U.S. v. Simons, in the year 2000, you had a government employee working for the Foreign Broadcast Information Service, or FBIS, which is a division of the CIA, who was suspected of using the office computer to download pornography. Without a warrant, the CIA remotely accessed Simon's computer, and over 1,000 pictures were found, some containing child pornography. Simons attempted to suppress that evidence, claiming a violation of the Fourth Amendment and his expectation of privacy. But the CIA has a very well-developed policy structure, and one of their policies, the Internet policy, allowed for periodic auditing, inspection, and monitoring of the user's Internet access. The court ruled that because an acceptable use policy existed, and quite frankly because the CIA monitored and audited those Internet access usages on a regular basis, that Simons had no reasonable expectation of privacy, and thus no warrant was necessary. In U.S. v. Ziegler, the FBI was notified that an employee of the ISP provider for frontline processing and a fiancé of a frontline employee was accessing child pornography. The FBI agent contacted the frontline IT administrator, who verified that the employee, Jeffrey Brian Ziegler, was accessing child pornographic sites. Frontline was already monitoring Ziegler's traffic, and Frontline owned and routinely monitored all workplace computers. There actually was some dispute in the case over who initiated the action of backing up Ziegler's hard drive, but a backup was made. At least one backup. In fact, I think several were made. Frontline's corporate counsel indicated to the FBI agent that Frontline would cooperate with the investigation. They turned over Ziegler's computer to the FBI, and the computer and one of the two backups of the drive were given to the FBI. The second backup copy was turned over sometime later. Forensics examiners found child pornography on the hard drive, but Ziegler sought to suppress the evidence obtained. His contention was that the FBI agent had violated his Fourth Amendment rights in that a warrant was not sought, nor was one presented. Ziegler contended that the FBI agent had directed the Frontline employees to enter his office and search his computer. The FBI agent countered that the search was voluntary and therefore was private in nature. The district court held that the FBI agent did direct Frontline to make the backup copies of the hard drive. However, citing the Simons case, Ziegler had no reasonable expectation of privacy anyway. On appeal, Ziegler contended that entry into his private office to search his workplace computer violated the Fourth Amendment, and as such, the evidence contained on the computer's hard drive must be suppressed. The court reasoned that since Ziegler was in a private office secured by a lock, he had a reasonable expectation of privacy, thus the Fourth Amendment would apply. The Frontline employees conducting the search were considered by the courts as de facto agents of the government by their actions. So this is an important contention with the Fourth Amendment that I made by indirect reference in the Fourth Amendment section. The Fourth Amendment only applies to government agents, unless when the government agents are in your corporate office and request that you provide them, say, a backup, and you go and make the backup, you are now acting as a de facto agent of the government by your actions, and the Fourth Amendment could apply by your activities. So the remaining question was whether the search was unreasonable. There's an exception to a reasonable search and seizure when there's voluntary compliance, but the question is, who can give voluntary compliance in the workplace? Since the voluntary compliance was Frontline's, not Ziegler's, the court had to decide if the company had possessed common authority over or other sufficient relationship to the premises or effects sought to be inspected. The court determined that Frontline could give consent to the search of the hard drive as the computer was workplace property and remained under the control of the company. Most importantly, Frontline routinely monitored internet traffic, and employees were notified upon hiring that the company monitored the traffic. Thus, an expectation of privacy by Ziegler could not have been assumed. The court thusly held that Ziegler had no reasonable expectation of privacy with respect to the use of his computer. In addition, the court held that Frontline had the ability to give consent to a search of Ziegler's office and computer. Although Ziegler retained a legitimate expectation of privacy in his workplace office, Frontline retained the ability to consent to a search of Ziegler's office and his company-owned computer. Because a valid third-party consent to search the office and computer located therein was given by his employer, the district court's order denying suppression of the evidence of child pornography existing on Ziegler's computer was affirmed. So the interception of email is prohibited by unauthorized individuals and individuals working for a government agency operating without a proper warrant. However, if the individual gives consent, you can intercept the email. Or if the provider of the communication service can monitor communications, the provider of the communication service can monitor communications, or monitoring is done on the normal course of business, then all three of those qualify as exceptions to those rules. So individual consent can be implied or it can be explicit. Some courts have placed a high standard of what constitutes implied consent. It may not be enough to assume that there's general knowledge of monitoring taking place. In other words, it's just common knowledge that the company does monitor. The employer needs to produce an email policy and an acceptable use policy that clearly indicates that monitoring will take place. And the employees should acknowledge in writing the context of the policy. The provider of a communications service can monitor communications. Where this is an employer, the ECPA allows broad discretion to read and disclose the contents of email communication without the employee's consent, and monitoring is done in the normal course of business. So, in companies that I've worked with, since we provided the computers and we provided the email service, we could examine the emails of individuals under the context of the HR and the legal department, should there be questions over some issue, and that was perfectly legal under the ECPA. However, we also had an acceptable use policy, an email policy, and security policies, which all had to be accepted in writing by the users after reading and indicating that they understood the policies.